Yes, Mr. Chairman.
Good morning, Lords. My Lords,
We are being live streamed, so can you use initials or something to anonymise the child?
Of course. Lord, I appear for the appellant in this matter, together with Mr. Evans, Professor George Casey, and Miss Miller appear for the respondent father. Both parties, unusually perhaps, are in court today. My client has the benefit of an interpreter, and she's at the back of court. We don't seek to interpret everything simultaneously, but she will use her best endeavours to interpret as we go along. My client does, of course, speak relatively good English. My Lord, of course, this is an appeal against the decision of Mrs. Justice Morgan, dated the 24th of March, and pursuant to my Lord Justice Moylan's order of the 12th of May, permission was granted. My Lords have that at page 77 of the bundle, and in particular the direction to the respondent to file evidence in relation to the dates upon which he received the British passport of the subject child, and in addition the Colombian passport of the subject child. My Lords will find that evidence now within the bundle, in particular at page 43.
Yes.
And what we have is an email dated the 13th of April 2024 to the father from the passport office, His Majesty's Passport Office, indicating that the British passport has been printed and that the accompanying documents will arrive separately and could take up to 2 weeks to arrive. Now, the accompanying documents in this case are relevant because that includes the child's Colombian passport. That is the only evidence that the father has produced. My Lords, I don't know if you wish me to seek to adduce this as fresh evidence as such, but of course it's been submitted into the bundle and my learned friends have referred to it at length in his skeleton argument, so it would be rather trite to...
and also I required it to be provided.
You directed it.
So it would be rather perverse if we didn't consider it.
Well, I thought I'd just double check.
Yeah.
So, my Lords, that's the evidence of the arrival of the British passport. That, of course, is a Saturday, the 13th of April, and the father, in his statement, and in fact in text message, which I'll come on to, says that he received the British passport on the 16th of April, and thereafter received the Colombian passport on the 30th of April. I'll come back to passports, if I may, in due course. I don't know if you wish me to detail the background to this matter in any detail. It's set out quite comprehensively in both skeleton arguments. But essentially, the mother's a Colombian national. The father, in fact, is an Ecuadorian national and British national. And they lived and were habitually resident in Colombia, including the birth of the subject child in 2017. The parties agreed. First of all, they separated, and there was an agreement and order within the Colombian courts for contact to the father, alternate weekends from Friday to Sunday, and effectively a residence order to the mother. And both parties lived separately, owned their own properties, and the child was enrolled at school in Colombia. There was an agreement which parties signed for the child to accompany the father to England for a limited period, a limited and temporary period of 3 months, from the 28th of December 2023 until the 6th of April 2024. And it was further agreed that during that time the child would be enrolled in school to facilitate and help her language, but that it was always agreed that the child would return to Colombia, where indeed her school place in Colombia had been kept open. The mother, in fact, herself arrived in England on the 28th of January, and she remained in England, working remotely for her company in Colombia, and living separately to the father and the child at an address of friends where she had previously au paired when she was younger. The Mother, in those circumstances, saw the child on a regular basis between the end of January and April, and the child stayed with the mother at various times by agreement between the parties. As my lords will know, there was a delay in the passport. And the delay in obtaining the English passport, although the father says he applied for it on the 2nd of January, there's no supporting evidence of that. The passport was delayed and didn't arrive. The mother says, in terms, further documents were required. But in any event, by the date at which the parties had agreed for the child to return to Colombia, approached and passed, and the documents and the passports weren't returned. The issue then arose as to when the passport would indeed return. And what we have then is details of what the father says in relation to those arrangements. We firstly look at page 117 of the bundle. Paragraph 41. The father says, Rachel's passport, or the child's passport, was taking longer than expected, and we were asked for various types of evidence. I showed the mother all the communication when we were together, which was very often. I was transparent with the communications. Well, that's plainly wrong, because on any objective basis, the father did not disclose the email, which he has now subsequently disclosed on the 13th of April. And so it was within his knowledge and gift, in fact, that he knew that the British passport was imminently going to arrive after the 13th of April, and further that the Colombian passport would arrive within 2 weeks. The father then says at paragraph 42, before the mother returned to Colombia, I suggested she wait a few more weeks so she could take the child back with her. However, she declined. That's not in fact right, and I'll come on to that in a moment. But the reality was that having received that email on the 13th of April, the father did not disclose that information to the mother. And she, in fact, left England on the 14th of April, the very next day, the father, in fact, taking her to the airport. Now, the judgment refers to the mother leaving on the 16th. I don't think it makes a difference for the issue of this appeal, but in fact, the reality was that the father did not disclose to the mother, as she left England, that the passport was about to arrive in the very near future. Had she known that, it's likely in our submission that she would have remained in England awaiting that passport to return to Colombia, as the father indicated was the agreement and that he was still agreeing to. And we see, in fact, the contemporaneous text messages between the parties, which are at page 149 of my lord's bundles. Firstly, we see a text message at the top of the page from the mother on the 2nd of April.
Sorry, can you give me the page again?
149, my lord.
Thank you. Yes.
You see a text message at the top of the page, dated the 2nd of April, where the mother indicates, I feel half deceived. I should have known. Now that's 2 days before the anticipated return on the 4th of April, for which tickets had been purchased. But later on in the text messages...
Tickets have been purchased at the beginning? Or?
At the beginning, the return tickets have been purchased.
Okay.
For return on the 4th of April. And of course the agreement was until the 6th of April.
Yeah.
We then look further down that page and we see text messages between the parties on the 12th of April. But crucially and importantly, there are no text messages from the father on either the 13th, 14th or 15th of April. He took the mother to the airport on the 14th of April and she left. On the 16th of April, he says the documents have not yet arrived. Only the passport has arrived. documents are taking a little longer. He doesn't indicate that they were going to take up to 2 weeks to arrive. And the mother is confused and she says, which documents? And he replies, everything, including my passport and the child's Colombian passport. There's then no further details as to that. But we then look at the bottom of the page on the 25th of April, where the father says, I'm told it can take 1 to 2 months for the passport to arrive. I'm praying they arrive quickly and trying to save for the new tickets. Now, that's not right. And that's not right because we now know from the email that the Colombian passport was going to arrive within 2 weeks. But it's an indication that the father was still at least outwardly agreeing with the mother that the child would return to Colombia, and indeed, as the mother had already left, that he himself would also be returning to Colombia. We then turn over the page and we see an entry which is 043024, which is about a quarter of the way down at 1402, where the father says, I spoke to the area postman and magically the documents seem to have arrived today.
Sorry, which time?
About a quarter of the way down, my lord.
Yes, oh, I got it. That's the 30th.
That's the 30th. And that is, we infer from the information we now have, but it's not clear at the time, that in fact was the child's Colombian passport. And miraculously, that date of the 30th is approximately 2 weeks after the 13th of April, but there's not one jot of evidence either produced at the time or subsequent to my lord's order to demonstrate the actual date on which either the British passport arrived or indeed the Colombian passport arrived. The father then unilaterally decides that he needs to register the child to obtain an English birth certificate. That then starts on the same date. Next step, child's birth with the National Registry Office so that she has an English birth certificate. It's not clear why the father had to wait for the Colombian passport when he already had possession of the English passport, which would be required to register her birth. So he effectively appears to have waited at least 2 weeks to start that process. But that was never part of the agreement as between the parties. The agreement was that she would obtain a passport. What other applications the father made after that were a matter for him. We then look at the bottom of the page, where the mother on the 6th of May, 3 lines up, says, how much money is needed, and you send me child with a flight attendant. I don't believe you anymore. So the mother was clearly suspicious of the father's intentions. She was, at all times, as the father rightly accepted at trial, at all times seeking for the return of the child to Colombia in accordance with the agreement, but that was being frustrated effectively by the father. And so when we go back to his statement, and he indicates he's being transparent about arrangements, we strongly disagree with that statement. And in fact, it's plain that he was being, at best, rather vague about what was happening, and clearly hadn't disclosed the information that he was party to in relation to the dates and times. Had that information been disclosed to the mother, we say she would have remained in England, awaiting the Colombian passport to return to Colombia with the child. And overall, that underlines the finding that the learned trial judge made in relation to the father's dishonesty and unreliability. We say in the circumstances that in light of that knowledge and in light of the father's behaviour, it was perfectly possible for the trial judge to determine that the date of retention was on or about the 13th of April. But when he knew when the passports would be arriving, he failed to disclose it and then further sought to delay arrangements by seeking to obtain a birth certificate, none of which we have any evidence about, none of which the father has produced. So when we come then to look at the judgment, the important aspects of this start, we say, at page 66 of my Lord's bundles. And it's important to understand the context of the mother's case, but it's summarised at paragraph 23 at the bottom of that page. Having set out the communications between the parties which I've just directed my Lords to, on this basis, the mother's case is that the father had decided unilaterally and wrongfully to retain Rachel in England and Wales by the end of May 2024, putting the relevant date at the 30th of May 2024. That, we said at trial, was the latest date. And we say in the circumstances, the learned judge paid insufficient attention to the relevant dates of the passport arriving. In particular, the father, within his statement, I'll just go back to his witness statement, because in fact, forgive me, I've just lost the. The father, in his witness statements, indicates that he knew the passport was going to arrive 2 weeks later, and that's relevant because, of course, he would only have known that. Yes, it's page 118 of the bundle, paragraph 45. The child's British passport arrived in mid-April without specifying a date, but other necessary documents took an additional 2 weeks to process. Now, that information, as we now know, comes from that email from the passport office. But the father was not being transparent when he wrote that. He doesn't give a date, and he certainly didn't indicate that he had the child's Colombian passport by the 30th of April. And then at paragraph 49 at the bottom, understanding that the process to register the child's birth and finalise the documents would take at least another month. The mother started exerting tremendous amount of emotional pressure on the child to convince me to take her back to Colombia, often reducing her to tears. Well, when the mother left on the 14th of April, it was clearly anticipated by both parties that she would be returning and that the child would be imminently following her on receipt of the passports. But that arrangement, as I've indicated, changed when the father sought to then register the child for the purpose of the birth certificate. In terms of the judgment then, as I indicated, the mother's case, summarised by the learned judge at paragraph 23, page 66 of the bundle, unilaterally and wrongfully decided to retain the child in England by the end of May. We say that date could now be determined as of the 13th of April.
So what are you suggesting that we should do? You're saying that the judge was wrong to find the 30th of May, and your submission is it that we should find instead that it was the 13th of April?
Yes. Yes, on the basis of the picture of Lord Hughes in Re C, and Lords, I've set this out at page 14 of the bundle onwards. But importantly, where at page 16, paragraph 51, Roman numeral 3.
Sorry, where are you taking us to?
On my skeleton argument, page 16 of the bundle.
Yes.
In terms of repudiation. Of course, repudiation doesn't strictly apply in this case because the agreement was limited until the beginning of April. but the point about retention remains the same, that it must be communicated. That does not mean that it must be communicated to the left behind parent. Require that would be to put too much of a premium on concealment and deception. We say it's plainly concealment and probably deception, where the father had that knowledge and didn't communicate it, where all parties at that point were agreed the child was going to go back. One asks rhetorically, if the father was agreeing to the child going back, why that information wasn't put forward, and why the mother was not told imminently that the Colombian passport would arrive, and that in those circumstances she and the child could leave England at the end of April. In terms of the judgment, then,
I mean, what if you go to sub Roman numeral 2 on page 16?
yes, ma'am.
What Lord Hughes said there was a purely internal, unmanifested thought.
Yes.
So, if purely internal, prominent light, etc. There must be an objectively identifiable act or acts of repudiation.
Yes.
So what do you say were the objectively identifiable
The objective act was that having had a discussion throughout the whole of the beginning of April, and the parties being concerned about the delay in the passport, the father, armed with that knowledge on the 13th of April, failed to disclose it and deliberately did not disclose it to the mother. And that's the identifiable act in which he then sought to make...
so failed to disclose that he had been told that the passports were on their way.
Yes, he'd been told...
While telling the mother, while not telling the mother that he knew that they were coming.
Yes, taking her to the airport, in fact, the day after, on the 14th of April, not disclosing that the passport was imminently going to arrive, but importantly that the Colombian passport was going to arrive within 2 weeks. Where he says in his statement, I was encouraging the mother to stay later to await the passport.
Mr. Jarman, I'm speaking for myself. I'm now a bit confused because
I apologise.
I thought a moment ago you said that this was not a case of repudiation.
Well, my lord, the repudiation or the early repudiation of the agreement would have to have happened before the beginning of April.
Those are two different points. Early repudiation
Yes.
is not necessarily the same thing as repudiation.
No, but it's effectively retention rather than repudiation. So the retention is on the 13th of April when the father had that information.
Procedurally, as I understand it, really what the judge had to decide was end of May or a later date. It wasn't really being put to her that she should decide in favour of an earlier date. Supposing it had been put, but that affected the evidence. I mean, the father was cross-examined on a very limited point. He wasn't cross-examined on anything else. No. In circumstances where it wasn't being suggested that the key date was April, is that an appropriate approach?
It may not make a great deal of difference to this appeal. It certainly goes to father's credibility.
But the judge has already said that she found the father's evidence unsatisfactory, so I'm not sure why that takes us any further.
Well, my lord's absolutely right, because the bigger part of my appeal is the issue of habitual residence. So, of course, the data retention is relevant to the time period, and what we're in fact talking about is about 4 weeks.
Yep.
And so, in the scheme of things, it probably doesn't make a great deal of difference in terms of the determination of habitual residence. But we say it's an important cog which was not before the court, and the father was not being candid and open in relation to those issues in particular. And importantly, the mother would have remained in England as I've submitted. So if we look, my lord, thank you for directing me in relation to the actual determination. The primary point of our appeal is the way in which the learned judge dealt with habitual residence. And we
Can I just sorry, going back, the position as at the 13th of April,
Yes.
13th, 14th, when your client returned to Colombia, was that the child and the father were going to return to Colombia as soon as they could.
Yes.
And the as soon as they could meant receipt of both the British passport and the Colombian passport, because the child was required to enter Colombia as a Colombian national
Yes.
with their Colombian passport.
And I think the father says that, in fact, his passport was also held, or sent
Right,
to him,
okay, as part
so he
of-
would have to use
okay.
his passport to travel with the child.
Anyway, but that so that the passports on the evidence we have would have arrived within 2 weeks of the 13th of April.
Yes. And the father says in the text message, magically arrived on the 30th.
I understand that, but so your case, picking up my lord's point, your case is, as I'm just trying to formulate it in my own mind, that there was the original agreement could no longer be fulfilled because the documents weren't available.
Indeed.
There was a replacement agreement between the parents that the father and the child would return as soon as they could once they got the passports.
Yes.
They got the passports by 26th, 30th of April,
Yes.
so that there was undoubtedly a wrongful retention you would submit as at that date,
Yes.
because he was then able to fulfill what I'm calling the replacement
Yes.
extension.
Yes. My lord's absolutely right.
Right.
Of course, the only question mark is when, in fact, the father received those documents.
I understand that.
It's within 2 weeks of the 13th of April when he received the email.
And that's why you say that it's no more than about 4 weeks, because it's either the end of April or the end of May. Yeah.
So, my lords, then, just going back then to the judgment, and
So whether it's a retention or a repudiation is probably dancing on pins. It could be both, or either.
I respectfully agree.
Yeah.
Yes. At page 70, we have the learned judge's distillation of the law in relation to habitual residence, and she sets out the agreed position in relation to the case law and details it at paragraphs 40 onwards, relying on the judgment of Justice Hayden in Re B and my Lord's judgment in Re M, which qualifies that list which the learned judge then sets out within her written judgment.
Well, if you look at Mr. Justice Hayden's summary, in paragraph 10, the relevant question is whether a child has achieved some degree of integration. Now that's how it was phrased there.
Yes.
And okay.
But as the court's directed us to the authority of Re A,
Yes.
that's not the whole question.
No, it isn't.
And respectfully, first of all, the learned judge did not make reference to that, perhaps because counsel, and forgive me, I wasn't present, but counsel didn't direct her to that particular authority. But importantly, as my Lord makes clear, that's not the only question. And we have Re A. I hope you have a copy of that now within your bundles, or we've handed up a separate copy this morning. But the judgment that you handed down, my Lord Moylan, in relation to that question, starts at page.
You want us to go to that now?
Yes, we can look at Re A. It's in the electronic bundle. I don't know if you've had that updated, but we handed up hard copies this morning as well.
I think it's at the back of the bundles.
And this was a case where the Pices lived in England for some 20 years, and although the mother was a national of Zambia. The child had been habitually resident in England for the entirety of his life. The parties agreed to go on a holiday for 2 weeks. The father returned, and then the mother effectively retained in Zambia. The father withdrew his consent, and an application was issued within about 3 months of the retention. My Lord, the important part of your judgment appear at paragraph 42, 323 of the electronic bundle, under the subtitle Legal Framework. And paragraph 42, you emphasise that in relation to the European case of proceedings brought by A, 2010, that the shorthand summary of the approach which the court should take that has some degree of integration is not itself determinative to the question of habitual residence. Habitual residence is an issue of fact which requires consideration of all relevant factors. There is an open-ended, not a closed list of potential relevant factors. You then list those important aspects over the page, but you in fact detail the judgment from Re A, paragraph 37 onwards, and we pray and aid that. Habitual residence, paragraph 37 of Re A, habitual residence of a child within the meaning of Article 8.1 of the regulation, of course that no longer applies, but must be established on the basis of all the circumstances. Paragraph 38, in addition to the physical presence of the child in a member state, other factors must be chosen which are capable of showing that the presence is not in any way temporary or intermittent, and that the residence of the child reflects some degree of integration in a social and family environment. We say the use of the word "and" is very important in that sentence, because it's not just about the degree of integration, it's about the circumstances, the reasons, and the intentions of the parties, which all feed into that question of residence. And so we pray and aid Re A, and we pray and aid the decision of Re A proceedings regarding A, which is set out in that judgment. Paragraph 41, for example, by contrast, the fact that the children are staying in a member state where for a short period they carry out a peripatetic life is liable to constitute an indicator that they do not habitually reside in that state. In light of the criteria laid down, according to the overall assessment, is for the National Court to establish the place of the child's habitual residence. Now, what the learned judge did in this case, I should just refer, my Lord, to paragraph 45 of the judgment. In Re A, I refer to the above not to put forward any gloss on the meaning of habitual residence, which the Supreme Court cautioned against in Re B, but simply to demonstrate that some degree of integration is not a substitute for the required global analysis.
Is the next paragraph of some importance as well?
Yes. The comparative nature of the exercise requires the court to consider the factors which connect the child to each state where they are alleged to have been habitually resident. Now,
it seems to me that's a pretty fundamental
indeed.
inquiry that, depending on the circumstances of any case, may have to be gone into. But
Yes.
one of the things that concerns me, at least, Mr. Jarman, is I'm not sure this is how the case was put to the judge. I don't see her doing a comparative exercise, but at the same time, I can understand why she didn't, because I don't think that's how it was being put.
Well, she, with respect, had to carry out the exercise to determine the issue of habitual residence.
Yes.
And if we look at her judgment, there is some comparisons between the different jurisdictions.
Right.
But what we say is effectively that she failed to place sufficient weight on those comparisons which she herself identified.
Well, the trouble is, once you start saying that it's a question of weight, then it's much more difficult for this court as an appellate court to interfere with her assignment of weight to various factors. Whereas if if your case had been that she's just not asked the right question, then one could understand why the Court of Appeal should get involved.
Well, my lord, it's a combination of both those, and she effectively misdirected herself because she focused solely on the issue of integration, thereby ignoring the other holistic issues, which she had identified to a certain extent, but then misdirected herself effectively to determine that the important aspect and the sole aspect was one of integration. And so when I come to her judgment in due course, I'll demonstrate that her use of language doesn't talk about her assessment of habitual residence. It talks about her assessment of the degree of integration. And that's where we say she respectfully misdirected herself and narrowed the consideration of the other important aspects.
Is that a slightly different point? I think what my lord was thinking about was comparative integration. So you, on this thesis, you would have to compare the degree of integration in Colombia with the degree of integration here. So it wouldn't be wrong to consider degree of integration. The complaint would be, well, you haven't looked at Colombian integration.
Yes. But accepting, of course, when the child left Colombia on the 28th of December, she was obviously habitually resident in Colombia. So there doesn't need to be a comparison or an inquiry as to her habitual residence before that date. The issue is whether her degree of integration, together with the other aspects, mean that her habitual residence has changed and subsequently become United Kingdom or England and Wales. And we say that when you look at the judgment, and then we start at page.
Before, sorry, I don't want to interrupt you answering my lord's question, but before we leave Re-A,
Yes.
I also think it's relevant to look at the next paragraph, 47, and look at Lord Wilson's list of sort of expectations from Re-B, one of which is the deeper the child's integration in the old state, probably the less fast his achievement of the requisite degree of integration in the new state. And it picks up the point my lord was making about the comparative you have to look at. And I think Lord Wilson gave the example of the whole family packing up and moving,
Yes.
being one type of situation. So it is clearly relevant for the judge to consider the extent of the child's integration in the what Lord Wilson refers to as the old state.
Yes.
And he was dealing with the case in which the child had moved, with the intention of one parent being that that move would be permanent.
Yes. Yes, my lord. And you'll see, although specific reference is not made to that case, the learned judge uses the word rooted within her judgment. And so, on one level, the learned judge is considering that, but as I make clear, it simply doesn't go far enough in relation to the holistic inquiry of the child's habitual residence. So, my lord,
Do we know what cases the judge was referred to below?
I don't have the certain arguments in the bundle, but
Right.
we can make it
Okay.
available, of course. As I understand it, forgive me, may I just turn my back? Yes, I'm told by the junior that the law as between counsel was agreed, and as I've just directed you to, they were set out by the judge in her skeleton argument.
Right.
And really by reference to Mr. Justice Hayden's summary.
Yes.
Yeah.
So, my lords, we then look at paragraph 70 onwards and the consideration which the learned judge gave to those issues. And paragraph 42, having gone through the law, the learned judge then says, as I have considered the degree of integration, that's her starting point. And we say that's, from the outset, our focus is on integration rather than on the issue of habitual residence. I remind myself that subject child is the focus of the consideration. Her own integration in social and family environment here is what matters. Well, it's an aspect that matters, but it's not the sole issue. And of course, the purpose and circumstances of her parents are also relevant to that question. It need not be complete that when what has frequently been described as some degree of integration is considered, the stability of that integration is of importance, as is the fact that the notion of stability is regarded as distinct from the notion of permanence. So, whilst the learned judge does consider other aspects, she then goes on further in that paragraph. Since they are here, competing claims of habitual residence as between the mother's case, Colombia, and the father's case, England, Wales, an element of the analysis of some degree of integration. But again, she over-focuses, we say, on the issue of integration, and its sufficiency or otherwise to establish habitual residence involves a balancing of connection and integration between the child and each of those jurisdictions. So on the face of it, she directs herself that there is a comparison. But at the bottom of that sentence, paragraph, she says it would be wrong for me to approach a factual analysis with her integration here without regard to the life lived elsewhere, her deep roots, and that's the reference to roots, in another state.
Yes, I have to say that now that I've been reminded that she does use the word competing. On the face of it, she does in fact appear to be doing a comparative exercise there.
She on the face of it does, my lord, but we say that effectively, having considered those, and you'll see from the subsequent paragraphs, that effectively is put to one side, and her focus is on integration, and in particular the fact that the child was at school, as directing her or determining her to find that habitual residence has moved to England. And we say that's the wrong approach in the circumstances.
Well, I know you say that, and I don't want to cover old ground, but if you go back to page 71, I mean, the very first paragraph of Mr. Justice Hayden's summary, which you've fairly told us was agreed, that summary was agreed as setting out the relevant legal principles. And the first one says the habitual residence corresponds to the place which reflects some degree of integration,
Yes.
etc. So I'm not sure the judge can be criticised for embarking on the very exercise she was being asked to perform.
Because we've directed you, and you've directed us, in fact, to re-A.
Yeah, well, that's a different point.
That's not the only question.
Yeah, that's all I'm getting at, is that it may be the judge was wrong in her approach, but not necessarily because she was being invited to take some different approach. It may be perfectly understandable why she was being, she was doing what she was doing, because that was the agreed approach at the time.
But that's one of at least 10 or 11 different aspects.
No, I understand. I do understand.
And we say that was the focus of her determination, not the other issues which were also set out there.
It does seem a bit harsher to criticise her for using the words some degree of integration when they're in inverted commas derived from Mr. Justice Hayden's summary and from the Court of Justice.
Yes, my lord, but I think that the difficulty is that that's a very narrow approach simply to determine that issue, and as my lord Justice Moylan makes clear in re-A, that's not determinative, and that's our complaint. Our complaint is that that effectively became the focus of her determination of habitual residence. And then, of course, at 42, I have considered the degree of integration that the child has in this jurisdiction. That, of course, is the focus from the outset, not the circumstances in which the child lived and had been in Colombia since her birth. Over the page, the purpose of the arrangement, paragraph 43, intentions of both parents were clear. There was a written agreement, signed and dated. She'd never lived anywhere else apart from Colombia. She was born in Colombia, and she had no connection with the United Kingdom in the sense of social and family integration. Towards the bottom of that page, it is reasonable to infer from all of that whilst having her roots and lived all her life in Colombia, the child is likely to have had an awareness of the English side of her heritage. He had, however, until December, never visited the UK even for a holiday. Her heritage isn't relevant, we say, to the issue of habitual residence, but clearly the fact that she'd never been to England and had no previous connection is, particularly in terms of the roots analysis of Lord Justice Wilson in the Reby Supreme Court Authority. As paragraph 44 is living all of her life in Colombia, was well integrated with her maternal family. Last sentence, a life which has been rooted since birth in Colombia. She will have been aware, paragraph 45, and understood the trip to England to be something less than permanent. She was age 6 when she arrived, and she would have been aware, likely to have understood that it was a holiday, no suggestion that there was, for example, anything else in the sense of her saying goodbye to her school friends, which of course she didn't do, anticipating that she would return, and indeed that her school place was being kept open in Colombia. The judge then finds at 46, the child would have been aware of the purpose of the trip to secure a passport. Well, I'm not sure that adds to anything particular, whether she was or not, I don't know. But at paragraph 47, she then says, by contrast with her experience of living in Colombia across 2 homes, she has lived in comparatively cramped conditions with the paternal family in England, as it was, disrupted living conditions as a learned friend submitted to the court, and at paragraph 48, importantly, she was enrolled only temporarily into school. So those are important factors, all we say pointing to habitual residence remaining in Colombia, deeply rooted, limited purpose to be here, time limited, and a written agreement, a clear intention of both parties. In relation to schooling, paragraph 49, the learned judge then says that the child has since moved to a new school. Well, that didn't take place until September 2024. And so that, we say, is not a consideration for the relevant date, which the judge was considering by the end of May. And further over the page, that by January 2025, when she had remained at the same school, she was described as performing below expected levels. And that, again, we say is an important consideration, where English is not her first language. Plainly, her English had developed and improved since her arrival in December 2023, but it was still below expected levels a year after she had started school in January 2024. And the learned judge then makes reference at the bottom of that paragraph. The fact that she's not taught in the medium of her first language, and that this in itself is further evidence of instability and further evidence that she would not have acquired by the summer of 2024 a new habitual residence. We say that's an important finding, which the judge then didn't apply to the consideration, the overall consideration. Paragraph 50.
Sorry, which is the finding?
That in relation to her underperformance to the described school, the fact that she is not taught in the medium of her first language, and that she is further evidence that she would not have acquired by the summer of 2024 a new habitual residence.
I thought that was just stating the submission, because the sentence starts, it's further submitted. So I'm not sure that is a finding.
Yes. But
Not
again,
sure.
An important aspect that she wasn't being educated in her first language, and she was still below expected levels as a year later.
Do you say the fact that she was still below expected levels a year later is of any significance?
It's not significant because, of course, the relevant date we're considering is May of 2024. But it's an indication of the judge's rather confused thinking about the issue of habitual residence, which we've made reference to in our skeleton argument. But different dates were being looked at when one was considering effectively the relevant date at the end of May.
But here, she seems simply to be recording a submission made on behalf of the mother that subsequent events threw light on what the position had been the previous year. I'm not quite sure how you can say that that's wrong. I mean, was she wrong?
No,
was the submission not made, or
it's wrong in the respect that insufficient weight was given to that particular aspect in the holistic consideration of this child losing her roots in Colombia and establishing sufficient roots in England and Wales to change her habitual residence. And then forgive me, I've just lost my paragraph 50, we're at page 74. Adults' intentions was not determined to remain relevant, and the judge accepts the clear evidence that it was a temporary stay, that it was not relocation, but she makes the point. I accept the clear evidence that at the outset it was intended the child would be returned to Colombia. Even it's right that the father had, in his own mind, determined that he would relocate, i.e. relocate to England. The father himself asserted, before changing his mind, he had foreseen the child returning to Colombia, and he had intended packing up and settling his affairs for there even to be a plan which would ultimately become one where the child, what he called a family, moved to England. And of course, it's right to reflect that the father had a property in Colombia. There was a dog that was left in Colombia, and he made arrangements for friends to look after that property whilst he was in England. Then at paragraph 51, the learned judge considers the mother's case on habitual residence. I've been careful to avoid the trap of thinking of it in terms of whether Rachel has lost her habitual residence in Colombia, and considered instead whether the matters on which the mother places reliance are such that when I look at the degree of stability and integration, I conclude that the child has not gained habitual residence here. We say with respect that the consideration should have been the holistic issue as to whether the child had gained habitual residence or changed habitual residence. That effectively, as we submitted in our skeleton argument, indicates almost a two-stage test, that the learned judge has to consider firstly whether the child's lost habitual residence, and then secondly whether she's gained a habitual residence. Again, it rather points to, we say, the rather confused consideration of the issues which we say the learned judge should have been determining.
Well, this is connected with your submission about paragraph 42, where the judge focuses, says what matters is the child's integration. When the judge says, I have to consider whether the matters on which the mother places reliance is such. Actually, can I go back? When she says I have to be careful to avoid the trap of thinking of it in terms of whether the child has lost her habitual residence, what trap is she thinking of?
Well, I respectfully am unsure, but I think, I'm simply unsure, but I think what is clear is that demonstrates, as we say, that her rather confused thinking about the holistic view of habitual residence. It's not to consider whether the child's lost habitual residence. The issue is whether the degree of integration of the other holistic issues mean that her habitual residence is now England and Wales.
Well, and she goes on, consider whether the matters on which the mother places reliance are such that, when I look at the degree of stability and integration, I should conclude she hasn't. And your submission is that's not the test?
No.
Well, that's not the approach.
It's not the approach, and it's not, in fact, the test. Paragraph 55. The relevance then of the mother being present for just over 2 months in England and Wales. Child used to having both parents in her life likely to have been mitigated. So the fact that the mother was here, the learned judge indicates that the stability was such that would have added to the issue, the positive issue of the child changing habitual residence. Well, of course, the mother was here herself for a temporary period. She was working remotely, and that, we say, was a wrong approach to consider that the physical presence of the mother, where the child was just sick and had been a primary carer in Colombia, was not an inference that she could draw as to the stability of the arrangement. The stability of the arrangement was still circumscribed by the temporary school place, temporary accommodation, and temporary time in England and Wales. And the inference to draw, and she, as the judge says, and I draw it, that the child will have understood her mother approving of her enrolment in school. Well, that again doesn't add to the issue of habitual residence. Plainly, the parties agreed that there would be enrolment at school, but that they would just be for one term. So we then move effectively to the determination of the judge at paragraph 59. She indicates that she's very carefully considered these issues and understood the value of engaging in the exercise. What she then says in terms is that about a third of the way down, in this case, I am satisfied that the child has a sufficient degree of social and familial integration to establish habitual residence. And again, that goes back to the primary submission, but also the first paragraph in considering this issue, where she over-focuses on the degree of integration. In reaching that conclusion, I've had regard to and taken care to reread before finalising my view the long and detailed statements of evidence filed by the mother, relevant to habitual residence of the concern. I have considered carefully that by no means all, but a good deal of her social integration, as is often the case with child this age, comes from her involvement in school. So again, there's no reference back to any of the comparisons of Colombia. There's no reference back to her deep roots and those aspects which she identified, but then doesn't detail in her conclusion in finding habitual residence has changed. And she, we say, over focuses on the fact that the child's in school as a temporary measure, but also clearly the intention of both parties to improve this child's English whilst she's here. And so when the judge says, is often the case for a child this age comes from her involvement in school life, that we say is a wrong approach and does not, in the holistic view of this case, point to a change of habitual residence. She goes on further down. To the extent that it's relevant, I consider that the mother, ironically, in recognising pragmatically that there would be benefit to the child continuing at school and completing the school year, was acknowledging perhaps unwittingly that the child had a degree of social integration. Well, that's simply wrong. The mother had no choice. She herself had limited ability to stay in England. She had to return to Colombia. She came over for a limited period to return with the child. And in circumstances where she was not being told the truth about the passports, she pragmatically agreed for the child to remain at the same school whilst that situation was resolved. But throughout that period from April onwards, the mother consistently and repeatedly said to the father, please bring her back, when is she coming back? And as the father in his own evidence indicated, when he indicated in May in a text message, or indicated May in a phone call, I don't think we have evidence of it, that he was thinking about staying in England, then he described the mother as being heartbroken. So, my lords, we say in those terms, the judge was wrong in her determination of habitual residence. she was wrong to find that habitual residence had changed to England, and in those circumstances, there should have been, pursuant to Article 12, a return of this child to Colombia. Now, my lords will be aware that, of course, the father defended the application on a number of grounds, and it's our submission that if my lords determine the appeal to be successful, you should make a return order. And we say that because, in terms, we say the Article 13b defence and Charles' Objector's defence have either so little merit or effectively have been dealt with by the learned judge within her judgment. And if we turn to Article 13b firstly, that starts at page 68 of the bundle. And this is the aspect of the father's oral evidence.
Sorry, where are you?
Page 68, my lord. Paragraph 31.
Yeah, thanks.
Of course, the intention of the father had throughout the whole of the period until he says May, determined that he would return with the child, and he was indicating to the mother that he was saving to buy tickets. But having given all evidence, and my lord already alluded to this, that the judge made findings as to his credibility in light of she finding him the most unimpressive witness on this aspect of the case. The logic of his position was near impossible to follow, and he therefore, over the page, determines that as evidenced by the ongoing discussion about it at an earlier stage, to bring the child back, leave her with the mother with a view to perhaps later, as a family unit, moving to the UK, he had no satisfactory answer. That was his case, and he had no answer in cross-examination. Neither did he have a satisfactory answer as to the fact that there had been no request for any protective measures. So he wasn't averring that anything was required in Colombia for this child to return, because of course his case was either the mother should wait a few weeks and go back with the mother, or that he was imminently going to return her to Colombia when he had the passport. The judge indicated that beyond speaking to his sister, there was nothing in the written evidence about protective measures, and of course he also had a property in Colombia, which he indicated had no mortgage, but he said, I do not have the deed until it's paid off, and therefore the judge was left at the conclusion of his evidence with the impression that Mr. Evans was right when put to him that so late in the day and unheralded asserted that he would not return. He had done so tactically to seek to strengthen his Article 13b defence. The father lived and worked in Colombia. He has his own property. His intentions were always to go back. We say that the Article 13b defence in those circumstances amount to very little, and therefore this court can make a return order.
Can I hear back to basics? I'm afraid that given the nature of the skeletons, I haven't been focusing on Article 13b at all. Where will I find it?
My lord, it's not within our skeleton at all. What we simply say is that if you determined our appeal was successful on the basis of habitual residence and not changed to England, then there's a mandatory return, subject to the defences put forward by the father.
So, is it in the bundle? Is it in the authorities?
My lord, it's not. It's not focused on at all in the skeleton arguments or the authorities. But we simply say that the discretion of the Court of Appeal in those circumstances would be to consider either to remit the matter for further consideration of the father's defences. Our submission is that those defences have next to no merit because they've been explored within the judgment. The judge has made a finding about her credibility, but in any event, the circumstances were such that this was a father who was always intending to return to Colombia himself, and therefore the Article 13b, we say, is...
And I might find it easier to understand the submission if I knew exactly what the law was. So where do I find it?
Well, my lord, we can supply you with the skeleton arguments of both counsel and the first instance, and they set out very clearly. They're not in the bundle for some reason, but they set out very clearly the law and the aspects on which the father sought to defend and the mother made representations about.
Mr. John, it's quite difficult for us to do that. The judge decided in paragraph 61 that it was unnecessary for her to speculate as to any approach she might have taken to the Article 13b defence. And as my lord has said, this hasn't really been foreshadowed in your... I mean, I appreciate that in paragraph 71 in your skeleton you say the court will be invited to make a return order.
Yes.
But the material that's relied on is set out in the statements.
Yes.
And so we would in fact be having to make the decision as though we were a first instance court and analyse all the material for the purposes of determining whether there was any or what merit in the Article 13b defence. Were we in a position to do
No,
that?
I respectfully agree. It wasn't an invitation to consider that in any detail, simply that on the face of it, there didn't seem to be any merit in it whatsoever.
Right, okay.
And likewise, child's objections, which the learned judge considers having heard the Kafkas officer, and that's set out at page 69.
So your submission is that if we can find in the judgment that the judge has effectively, although she said she didn't indicate that the judge has effectively
Yes,
analysed the material.
she has in fact.
Right, okay.
And likewise within child's objections, having heard the Kafkas officer, and this is at page 69, Kafkas officer is very clear that...
No, I see that. Nothing that amounted to
Yes.
an objection.
And so, although the judge also makes reference to not having made any conclusions about that, it's crystal clear in our submission that there is a finding effectively, but this is a preference, not an objection. So, if my lords were minded to the matter, then we say that you could effectively knock out child's objections, and if the matter needed reconsideration of the Article 13b, then that should be the sole defence available. And of course, time moves on. This child's been here since December 2023. The mother's been in England, in fact, since the beginning of these proceedings, but she has to return herself to Colombia next week because that's the expiry of her 6-month visa. And she, of course, strongly urges my lords to allow the appeal and allow her to return, but that may not be practical in the circumstances.
Suppose we were, and I stress this is not expressing any view, provisional or otherwise, just hypothetically. Suppose we accepted your case that the appeal should be allowed,
Yes.
but rejected your argument that we should simply make the order for return.
Yes.
What would then follow? Remittal to the High Court?
It would be a remittal to a different judge of the High Court.
Why a different judge?
Well, my lord, I think it's... I can't think in my limited experience, and I of course defer to my lords, but I can't think of any particular case where there's been a remittal back to the same judge.
I see. All right.
It would be unusual, but perhaps not unprecedented.
So there can be. I think it all depends. This
Yes.
kind of issue arises in many different fields of law,
Of course.
not just in family law. There can be good reason to remit it to the same judge if, for example, they've conducted a long trial, heard a lot of witnesses,
Indeed.
they're immersed in the evidence, and an appeal may be allowed on any one
Yes.
point of law or something
if-
like that. But it all depends.
No, of course it all depends. But if my lords determine the appeal was successful, you'd have to find the judge was wrong in their approach.
Yes, I see.
And in those circumstances, there may be an issue of confidence in the judge to
Yes.
deal with other issues.
Yes, well, that sort of point is often made when we consider appeals in employment cases.
Yes.
That if a judge has actually taken simply the wrong approach
Yes.
to the evidence, then it may be better, as you say, for confidence if it's remitted to a different judge.
And of course, she had limited dealings with this case. It was listed for one day. I think she heard evidence on the 18th and submissions and gave judgment on the 24th. So.
Right. Thank you.
Lord, unless there's anything further.
Well, can I go back a stage? You seem to have taken it or assume that if we decide that the judge, we were to decide the judge had not properly determined the issue of habitual residence, that we are in a position to determine that, and that we should determine that she was habitually resident, remained habitually resident in Colombia at the relevant date, be that the end of April or the end of May.
Yes.
And that is your submission, I'm assuming.
Yes.
You would not submit that that needs to be remitted.
No, my lord. We say all the evidence very strongly points to habitual residence remaining in Colombia, for the reasons, in fact, identified by the learned judge in her judgment.
And it is an issue that is invariably decided on the papers in these sorts of proceedings.
Indeed. Although the father gave all evidence, but that was really about the Article 13b, not about habitual residence.
Thank you very much.
Thank you, Lord.
Yes, Mr. George.
My lords, if it assists, we have hard copies of the skeleton arguments from the court below with us. I don't think I need to take your lordships to it for my submission, but we can hand them up so that those are available if that assists. I'd like to, if I may, start by a confession that having seen the edition of Rie by my Lord Justice Moylan, it occurred to me that our skeleton might have helped your lordships more had we actually set out a summary of what we say the law is, which we rather skipped over and got straight into the grounds of appeal. So I apologise for that. But we gratefully accept the addition of Rie into the authorities before the court, and those paragraphs that Lord Justice Moylan has taken us through already, we say are a fair and accurate summary of the correct approach. What the judge had before her, though, and this is of significance, was an agreed legal position. And the agreed legal position primarily focused around Mr. Justice Hayden's well-known summary in the High Court decision called Re B, subject to the caveat of this court's judgment of Re M. The judge had Re C before her, though whether it actually was relevant or not, I think is a matter of perhaps academic debate. And she also had on our side the High Court's decision of Re IK, which I think is authority only on a very minor point that I don't think is in dispute. The judge did not specifically have this court's judgment in Re A, nor this court's judgment in Re GE, which is the comparator approach point that your lordships have been through before this morning. However, although she didn't have those authorities before her, our case very clearly is that she's correctly applied the principles that are set out in those authorities. And so, if I may start with the GE comparator part.
So, just before you do, looking at, and it's quite often cited, Mr. Justice Hayden's judgment in Re B.
Yes.
I'm just wondering whether it's not as helpful as people seem to think it is.
Well, I say for my own part, I don't tend to cite it, with no disrespect to Mr. Justice Hayden.
Because it emphasises in the first Roman numeral, corresponds to the place which reflects some degree of integration, and that's a false summary.
And of course,
False is liable to mislead.
One can of course understand where that comes from. It's a phrase that originates in the European proceedings in A. It's repeated a number of times, including in Lady Hale's judgment in A and A.
Yes.
But as my lord points out in Re A, for the third A case in a row, the question isn't some degree. If there's going to be a summary, the question is sufficient degree.
Well, and yes, but it's also, you see, one says corresponds to the place. 10 says the relevant question is whether a child has achieved some degree of.
Yes.
So, and sufficient, yes, but it's sufficient in the context of the comparative exercise. So you can't even say sufficient is a freestanding question of its own.
No. Well, my lord, I don't disagree with those points. But in relation to the judgment under appeal, looking at the substance of what Mrs. Justice Morgan has actually done.
I understand that. I was just asking
yes.
for your assistance on whether it might be appropriate to caution reliance on the summary contained in Re B?
Well, I think, my lord, I would respectfully say yes. We've already seen that subparagraph 8 of that summary in Re B is knocked out by this court judgment in Re M. And if one then reads across the 2023 Re A decision, then the effect is to rather fatally flaw that summary that Mr. Justice Hayden gives. But there are two, well, that's what I say about the authority in its own terms, in the abstract, in that what your lordships may wish to think about saying in relation to it in a judgment. But there are 2 points in relation to this appeal, which I think rather cut against that argument. The first is, this was the agreed position that was put before the court, and so it's a little difficult to now criticise the judge for adopting the agreed position.
Can I just ask you to pause there?
My lord.
I have sympathy with that approach, speaking for myself. But this is the Court of Appeal, and we have to get the law right. So it's not a question of criticising the judge. The judge may have acted perfectly understandably in the light of what was being submitted to her then. But if in fact the law is different, we need to say so, because we set binding precedents.
My lord, I accept that, and that comes in effect to the second point I was going to make, which is that when we look at the substance of what the judge actually did, she doesn't rely on that shorthand that is criticised in Re A. And my lord, Lord Justice Moylan will recall I was for the appellant in Re A, making the exact criticism that the summary adopted by the judge in that case had led her into error. So I'm well familiar with the challenge that the trial judge faces in that regard, and I entirely accept my lord's point that this court cannot simply endorse an incorrect statement of the law, but the question of whether the judge actually got it wrong when she came to the application is a different question, in my respectful view. And so,
before we just leave, I hope my lord will forgive me if I just say, if this court is going to say anything further about Mr. Justice Hayden's summary, can we just remind ourselves of what my lord said in Re M at page 62 of the bundle of authorities?
yeah.
And it's paragraph 63 of the judgment.
Did I endorse it?
Well, but I'm just reminding ourselves that we may have to look at that, because clearly this is being cited now, with subparagraph 8 having been knocked out. Otherwise, possibly incorrectly, first instance judges do seem to be treating the Hayden summary as otherwise something that they should apply. Now that may need to be clarified.
Yes.
I think it's fair to Mr. Justice Hayden to say there have been, that summary has been considered by this court on a number of occasions, and I think Re M is the only one that specifically takes issue with it. Though
Well,
Re
except
A
that as my lord has astutely pointed out, has said it's a helpful summary.
Yes, although my lord, I noted just above the actual quotation within 63, you say if Hayden's summary is being considered, this paragraph. So there is a degree of latitude, perhaps,
well,
in yours wording. While I'm on that page, in fact, of the authorities, my Lord Justice Moylan asked what the trap was that Mrs. Justice Morgan is referring to, and this is it, in fact. So if one looks at the end of paragraph 62 and into 63, the trap that she's referring to, and I'm reliant on my learned junior who was there as to what was being discussed that led to this point in her judgment, but the trap is in focusing too much or only on the loss of a previous habitual residence and not focusing adequately on the question of where is the habitual residence at the relevant date. And so I think that's what we see alluded to in Mrs. Justice Morgan's judgment when she talks about avoiding the trap. It is making sure that she's within the final sentence of paragraph 62 of my Lord's judgment in Riem. This is not to say continuing or historical connections are not relevant, but they are part of, not the primary focus of, the court's analysis when deciding the critical question, which is where is the child habitually resident, and not simply when was the previous habitual residence lost, and then subsequent paragraph to remove subparagraph 8 from the re-B list. So my answer to your Lordship's question about trap is that's what she's referring to.
But do you accept that you can't have more than one habitual residence at a given time?
My Lord, I don't accept that.
You don't accept that?
I think there are some children, if I may allude to a case I once had involvement with, a child who was on a 2-week on, 2-week off basis living between here and the Netherlands, and lived for months like that, 2 weeks here, 2 weeks there. I think that child had as much integration in both of those places, and probably had...
But when they were here, they were here.
When they were here, they were
when
here.
they were there, they were there. So when they were
neither
here, they can't have been habitually resident in the Netherlands when they were here.
Well,
Or they could have been, but they can't be habitually resident in both.
Well,
Is there any case that says other than you can only have one habitual residence?
I'm not...
In this context, for the purpose of the abduction convention. Otherwise, I don't see how that
I don't think
convention
there is
can work.
authority that of more than one, but I'm not sure, and I'm of course stand to be corrected, that the authorities specify one can only have one. Lord Wilson tells us it's unlikely you don't have any, but I stand to be corrected, and I don't think it matters for this purpose of this case, because the question is about the change. This isn't a child who was in that way going back and forth.
So at least in this context, there will be one habitual residence.
Yes. Yeah. The child had either become habitually resident here on the relevant date, which I'll come back to obviously in a moment, or she hadn't.
Yeah.
And it's a factual...
But that does, forgive me, I don't mean to interrupt you, but that does suggest that in this particular case, actually, one does have to ask, is the child still habitually resident in Colombia, or is she now habitually resident in the UK?
My Lord, I accept there is that comparative assessment, and I think that's what REGE tells us. And I was indeed going to go through where we see that happening.
I see.
So although REGE is not cited and was not put before the judge by either counsel, in practice one finds that analysis in Mrs. Justice Morgan's judgment, and indeed a lot of it.
Yes, I mean, I was troubled by the use of the word trap, because it's not a trap. I mean, it wasn't designed as a trap. As my Lord has said, the court has to ask, when you're looking at whether the child is still habitually resident in the original country, that's still a relevant question, or has she become? And that's part of the process of reasoning that a court might be well advised to go through when deciding where the child is habitually resident. It's extraordinary how many cases there seem to have what is always said to be a simple issue of fact.
Yes, it's a straightforward simple issue of fact.
Straightforward
except when it's
issue of fact.
I'm not attached to the word trap. I'm simply trying to explain what I think.
No, I understand. I was concerned to see it being averted to as though it were a trap. When I think all I was trying to say was the judge in that case had focused too much on had the children in that case lost their habitual residence. So focused on one element rather than actually looking at the overall picture.
Yeah, no, I don't have any difficulty with that summary, which I think is clearly what Riem tells us. Can I just take us through that comparative exercise that we do see in the judgment? And it kicks off page 72 of the bundle, paragraph 42 of the judgment. And we've been through these paragraphs. My learned friend took us through them. And it kicks off with the judge saying, as I have considered the degree of integration the child has in this jurisdiction, I have reminded myself that it is she, the subject child, who is the focus of that consideration. And she then goes on to talk about 5 lines up, balancing of the connection and integration between the child and each of those jurisdictions, i.e. that which the child had in the state where she resided before, as well as that which she has here. And she starts what then is a further 4 paragraphs of analysis of that by commenting on the deep roots that this particular child has in Colombia. And so she's very aware, Mrs. Justice Morgan, in her analysis, that she is starting from a position of a child who has those deep roots that is the allusion I think my learned friend says to Lord Wilson's judgment.
Yes. What, as you will know, Mr. Jarman focused on to begin with was the second sentence, which is her own integration in social and family environment here is what matters.
Yes.
As though, well, okay. Is that too narrow? Is that too?
Well, my lord, there are, I suppose, 2 points that I make about this. The first is that as a matter of substance, one has to be cautious not to get caught up on the precise words that a judge is using in a judgment. We're not evaluating a statute here, we're evaluating a judgment, and we have to think about substantively, what does she actually do in her judgment? Which factors can we see being taken into account? How are they being weighed? And so this is the first point. I'm still on it, if I may expand it slightly. I think, as I understand, one of the points in relation to this phrasing being inadequate is that it, for example, doesn't include things like parental intention. And insofar as that is the criticism, when we come to the substance, it doesn't hold water. Because if one skips down to paragraph 50, for example, of the judgment, the judge plainly considers intention of the parents. So, insofar as there is a criticism to be made, the question can't be simply what words is the judge using. The question must be of substance. What has she actually done when it came to the analysis? The second is, and this may be my failing, but I have to say I don't actually see any difficulty with her summarising in this way the degree of integration of the child in a social and family environment, whether that integration, which takes into account and focuses on the child's perspective, as Mrs. Justice Morgan multiple times reminds herself that she needs to do, those factors that go into integration, in my submission, are indeed the factors that establish habitual residence or not on a factual basis. And I think there's a limit to the extent to which we can expect a trial judge to spell out every time they begin a paragraph or a sentence dealing with a habitual residence assessment, the full test each time. And so we see, importantly, within paragraph 42, the judge qualifies. It's one of the 2 places in her judgment that she in inverted commas, as my Lord Justice Newey says, puts in inverted commas some degree of integration. This is one of the 2 paragraphs of the judgment where she does that herself rather than merely quoting Mr. Justice Hayden. The first is at line 4 of paragraph 42. She says, what has frequently been described as some degree of integration, the important thing, she says, is the stability of that integration, as is the fact that the notion of stability is to be regarded as distinct from permanence. So the first qualification she gives to it is there. The second qualification about 6 lines up from the end of that paragraph, she says, where there's this comparative element of the analysis of some degree of integration in inverted commas and its sufficiency or otherwise to establish habitual residence, that involves a balancing of the connection and integration, and etc. So here's the second qualifier that Mrs. Justice Morgan puts on it. And in my submission, that's a qualifier that takes us back into the territory of Rie in this court, of the need to not think about some degree, but sufficiency of degree of integration, and to be taking that beyond some degree which could be established in almost any case where the child had physically arrived here, if they arrived with a family member. I've taken myself slightly off course, so I'll come back to those points where we see the judge actually apply that, because I'm still on read GE and the comparative point. And so my learned friend took us through paragraphs 43, 44 and 45. But all of this is about life in Colombia. This is the child's integration. This is what she has there. And we can see she'd never lived anywhere else. She had no connection with the United Kingdom in the sense of social and family integration. Her parents spoke to her both in Spanish and in English. She went to a bilingual school, but her first language is Spanish. Her roots and all her lived life is in Colombia. She never visited the UK even for a holiday. Then into 44, talking about family life in Colombia, her grandmother there, school friends, cousins, who she told Kafka's officer she misses. All part of her social and family integration. A life which has been rooted since birth in Colombia. 45, we see comment on the parents' communication to the child about what this trip was about and why it was going to take place. That she would understand it to be something less than permanent. All of these factors the judge has plainly taken into account because they're in a judgment. And my learned friends seem to say that she didn't come back to them later. But I mean, this is the analysis. We're at paragraphs 43 to 45, 6 of a judgment that only runs to 62 paragraphs.
But is it not really fair to say that she doesn't come back to them? She sets out these things, but then the rest of it is all about the position in this country.
Well,
There's
my lord,
no assessment of the comparison with Colombia.
well, my lord, the ultimate question for the judge was, at the date of wrongful retention, was the child habitually resident here? Because
As opposed to Colombia.
Well, as opposed to Colombia, but in a sense, as opposed to anywhere other than here, because the question was whether it was a wrongful retention here or not. Obviously, in this case, the only plausible alternative is Colombia. And I don't think anybody suggests there's any possibility she had no habitual residence. So yes, I'm being unnecessarily difficult. The answer is simply yes to your question, my lord. But the fact that these factors are all here is a matter of structure, of how she structures the judgment. I mean, she could have come back at the end and put a paragraph in and said, referring back to my analysis at 43 to 46, I compare in this way, but I think we have to assume that she's done her job correctly, and I say that not as a matter of courtesy, but as a matter of law, that Piglovsky, which I know this court will be well familiar with, tells us that we must assume the trial judge who has directed herself appropriately has applied the law correctly, unless it is actually shown that she hasn't. And so here, all of the factors she was supposed to take into account are plainly visible on the face of the judgment. And the fact that she didn't put in a paragraph that says, thinking back to those paragraphs again, can't be a ground of criticism in my submission. I'll deal briefly with 3A, the other non-cited authority before the judge.
Have you stopped going through these paragraphs, or are you going?
I've stopped going through those particular paragraphs, my lord. But I'm
Going to come back to the other ones, or I just wanted to go to paragraph 50 because you referred to intentions.
Yeah.
Adult intentions, whilst not determined to remain relevant, I accept the clear evidence that at the outset. What does she mean by that? Why the outset?
Well, by the time of the wrongfulness of the retention, what makes it wrongful, of course, is that the father's intentions have changed.
I understand that, but at the outset, I mean, throughout the period up to at least the end of April, the father was saying, I'm coming back, or the child's coming back.
Yes.
Indeed, probably up to the end of May, the father was saying, I'm coming back, the child's coming back.
And I think that's why the 30th of May is alighted on, is because that's the first time he
Right.
communicates.
So the adult intentions throughout the relevant period, i.e. up to the date of the wrongful act, were that the stay here was temporary.
Well, I suppose, my lord, there are two different points, and you can see this. The judge goes on to refer to this. That in terms of the wrongfulness of the retention, there has to be, as this is what REC tells us, some sort of manifestation of your changed mind. But of course, one can, as REC tells us, change your mind privately, but not do anything about your changed mind, and that doesn't trigger.
That's not. Yes, I mean that's not the point I'm asking you about. I'm asking you about that this was a temporary stay, and all the both parents and probably the child knew it was a temporary stay throughout January, February, March, April, May.
Well, I think the point that I'm answering two ways, if I may.
Yes.
The way the judge is thinking about it, I think, and we can see this if we carry on through that sentence. She says, even if it be right that the father had in his own mind determined he would relocate, as in permanently live here, that appears to have happened at some point in April or May. So there's a period of time when the father in his own head is starting to think about relocating here. We see in the evidence there's a discussion about the mother applying for a job here. She's preparing a CV for a job application, and we can go to that if that's helpful, but it's an aside in a sense for the point we're on at the moment. So there's a slightly fluctuating discussion between the parties. I'm not suggesting there was ever a shared intention for a permanent stay, but there was a discussion about whether that was a viable option to think about, and it wasn't just a trifling discussion, because the mother, as I say, discusses the CV and the job application that she's considering.
Right, thank you. Yes, sorry, you're taking us to...
I think I was going to make a second point about paragraph 50, but I'm afraid it's forgotten.
Sorry, I interrupted
gone
you.
out of my mind what it was. I'm sure if it's important, it will come back.
George, if you had finished on that question, can I ask you about paragraph 51?
My lord, yes.
Because I don't know if you were coming back to that. Please return to it if you were. But what's been submitted by Mr. Jarman is that there's a misdirection of law in paragraph 51. And we've already discussed the first half of it, I think, which is the losing habitual residence in Colombia point. But if I can put it this way, in the last 3 lines of 51, the judge appears to pose the question that she has to decide as being this: I have considered instead whether ... I should conclude that the child had not gained, and she emphasised the word not, had not gained habitual residence here. Now you may say that that's perfectly correct in law. Mr. Jarman submits that's incorrect in law.
Well, my lord, my submission is that when there is a binary choice, as there is in this case, between the child being still habitually resident in Colombia or having become habitually resident in this jurisdiction, it's a distinction without a difference. Whether you describe the question as being, which I think is probably a better way of describing it. I'm not shying away from saying that this is a judgment that, like any judgment, might have been expressed marginally better. It might be better to have said that the question is whether the child has gained habitual residence here, but the mother's case is that she has not gained habitual residence here, and that is in effect what's being... the judge is looking at the mother's arguments here. When I look at the matters on which the mother places reliance, the question she's asking is whether they show that. So in a sense, because she's focused herself on the mother's case, which is that there is no habitual residence here on the relevant date, I think that's what leads us to that. So if we're starting from scratch and we get to write the perfectly worded judgment, then I might have put it differently. But I say with respect to the judge, this is a perfectly adequate way of putting it.
Can I say the problem, speaking for myself, that I have with that is that it doesn't begin to be a comparative exercise. She's not saying, is the child habitually resident in Colombia or here? She's saying, am I able to conclude, looking at the degree of stability and her integration, that she's not habitually resident here? That isn't the question. There is no comparison, or is that a comparison? I mean, how can you say that is a comparative exercise?
Well, I think it inevitably is a comparative exercise, my lord, because going back to my Lord Justice Newey's question of what are the alternatives being posited here, there's no suggestion that the child has no habitual residence. There's no suggestion of any third country to be involved. And so in thinking about whether she does or does not gain habitual residence here by the relevant date, it's inevitably comparative. And when we consider the judgment overall, I go back to those paragraphs where she has gone through in detail about the life in Colombia.
But this seems to presume that the degree of stability, the degree and stability of integration is such that she is habitually resident here, subject to any points the mother might. So it rather presupposes the answer.
Well, my lord, I respectfully don't read it that way.
Right.
And I think when again one steps back and looks at the entirety of the judgment, I can skip us down for a moment to 59. This is one of the two parts of the judgment where the judge, in a way perhaps unusually, openly accepts that she initially had one view, but came over the course of the hearing to the opposite view. And so she talks about the attractiveness and initially persuasive case that the Moylan friend Mr. Evans made on the mother's behalf. So I don't think there's any reason to think when we look at the overall judgment that the judge started with any preconception, and indeed she cautions herself through paragraph 59. The more I've engaged in the exercise to which the long line of authorities directs me, of looking at the factual situation of this particular child, the less convinced I have become of that initial persuasiveness. So if anything, the judge started with the opposite view, and her analysis, in my view, in an impeccable judicial approach, brought her to the conclusion that was contrary to her initial inclination.
Suppose we were with you on that and everything else you've said so far, but we thought that the conclusion she's reached is simply one that was not reasonably open to her on the facts. Does that permit this court to interfere?
My lord, I think the answer in theory is yes, but I would say that in practice, this judge has explained her reasons very clearly. She has set out which factors she would react to and why. And it comes back, if I may say, with respect to my lord's question to Mr. Jarman about weight, that if we're talking about the weight that the judge has given to evidence, which is where we will be if that is the question, then it is quite difficult for this court to think that it is in a better position than the judge was to make that assessment of weight, bearing in mind she had 2 days dealing with this case. She had a short amount of oral evidence, not on habitual residence, but it clearly is relevant to her overall assessment of the case because she deals with it in her judgment, and it's not favourable to my client. And her entire approach is to say that she is putting herself into the shoes of the child and thinking about what did her life look like, which is, and those are my words, not hers, but that is the correct approach. And so, excuse me, of course, a judge may make a decision that is so far outside the bounds that this court can interfere with it. But these are effectively factual determinations. And in my submission, this court would have to be very confident that this is a decision the judge could not reasonably reach. And I say there's no basis for considering that to be the case.
Just picking up the other aspect again, the comparative question. Reading paragraph 59, might it be said, well, it really looks as though the judge is focusing on the question of whether a bar of sufficient degree of integration here has been cleared. It's all about this country. There's nothing about Colombia, actually.
Well, one has to be careful here, because the ultimate question is, was the child habitually resident here? That is actually
the ultimate question is, where was the child habitually resident? That is the question.
yes.
Because if you say, was the child habitually resident here, you're automatically slightly tilting the balance. It's a completely neutral balance. Where was the child habitually resident at the relevant date? Now, you phrase it the way you do because the child was, depending on where the child was habitually resident, depends on the application of the convention. But the question is neutral, I would suggest. Sorry, I said that rather vehemently. It was a suggestion. Can you take it, Mr. George? It was a suggestion. What would you say to that suggestion?
Well, slightly difficult for me to
No.
say anything, but I think, my lord, my answer to the point is how the judge exactly expresses that is not as important as what did the judge actually do. So whether she says, as evidently it turns out I would have said, the question is, because this is what we are asking in a Hague Convention case, is the child habitually resident here or not? Because that's what the father has to prove in order to, that's what the mother has to prove, is that the child is not habitually resident here. Otherwise, her Hague Convention case doesn't get off the ground. So this is one of what I sometimes term the elements of the Hague Convention. Most of them in this case are not in dispute, that both parents have, or the applicant parent at least has rights of custody, that she was exercising the rights of custody. These are not in dispute. One which is in dispute is the habitual residence issue. And because it is her application, it is for the mother, on the face of it, to bring her case. Obviously, in reality, both parents bring their cases about that. That's what RIK.
Quite. I mean, if you were phrasing in terms of the convention, the question would be, at the relevant date, was the child habitually resident in Colombia? Because if she wasn't, then the convention doesn't apply.
I accept.
Do you see
that,
what I mean?
But from the perspective of what the parties are each putting forward a positive case about habitual residence, evidently, and I think whether one phrases it in the case of the mother's application, which is that the child remained habitually resident in Colombia, the father's case, the child had become habitually resident here, or perhaps I'll accept, preferably, my lord's terminology, which is that we don't need to put any of those things and we simply ask where. But whether these nuances actually affect what Mrs. Justice Morgan did, in my submission, they don't. And we can't ask her to keep coming back again and again to factors that she has set out very carefully and in detail in her judgment. So she set out the case about Colombia. She starts with the deep roots in that state, and it's not a linear analysis just because she sets things one point first and the second point second. she's putting all of these things into the balance, and she reaches a conclusion at the end. Can I take us to Re A? I don't mean take us to it, but just to deal with how, even though it's not referred to, I say that's not a flaw in this judgment. So, if one goes back to the decision that was under appeal in Re A, my learned friend gave a helpful summary of it in relation to the trial taken to Zambia. The approach that the High Court judge in that case took was, in effect, simply to ask whether there was some degree of integration in Zambia, in that case. And on the basis of that some degree of integration, found that jurisdiction had passed. When one looks at the parts of that judgment that are quoted in my Lord versus Moylan's judgment, we can see quite a different approach to that which is taken by Mrs. Justice Morgan in this case. I already highlighted within paragraph 42 of Mrs. Justice Morgan's judgment the two ways in that paragraph that she goes beyond the quoted, in inverted commas, some degree of integration approach. But most clearly we see this in her conclusions at paragraph 60.
Sorry, are you taking us away from Re A? Or?
Sorry, I am. Yes, sorry, I didn't mean. It didn't mean, in fact, to be in Re A. Only that I was summarising what
okay, sorry. Right.
told us. But I to go through it if that's helpful. But within Mrs. Justice Morgan's judgment, 60 at the end.
Yes.
She says, this child has, in my judgment, by the 30th of May, and even more so if the date is in July, achieved not just some degree of social and familial integration in this jurisdiction, but a significant and, I find, sufficient degree to establish that her habitual residence lies here. And so thinking about, does the judge in fact apply the Re A mantra and avoid what I perhaps won't call the trap of overly summarising the approach as some degree of integration? She plainly goes very far beyond some degree and makes a finding of significant and sufficient degree of integration here. And so I think, my Lord, coming back to your question about is the court in a position to, if you say this is outside the bounds, this is a judge who has found that this is not a marginal case. She says she initially thinks that it is, but as she goes through the analysis, she concludes that it is, in fact, a clear case.
I know that she does express that conclusion, and she says that in paragraph 59. But can we just examine what is it on the different sides of the balance? On the one side of the balance, in favour of Colombia, is what she says at paragraph 43 down to 45, life rooted since birth in Colombia, goes to school there, and we know that her school place in Colombia was being held open by the payment of fees.
Yes.
Family there, cousins there, she hasn't said goodbye to her school friends. So all of that suggests that where we're heading is, it's Colombia. And then what's said is that there's an agreement that she should temporarily attend school in England for a period of 3 months from January. And then there's reference to the fact that she's moved to a new school, but that's after the relevant date, because that's September. And that's a separate ground of appeal, incidentally. And that may have merit, I don't know. But looking at the balance that's conducted is adult intentions are taken into account. They're not determinative, fine, but the adult intentions were, certainly so far as the mother is concerned, have never changed, that the child should go back to Colombia. And that seems to have been the father's agreement certainly so far as the mother was aware, up to the time of the relevant date, even if we take that to be the end of May.
Yeah.
Right? Then you have that she lives here with her paternal family in the accommodation that they have. It's not as good, it seems, as she had in Colombia, but there it is. For what it's worth, it's not just school attendance here, but there is living here. And there was and she's registered with GP, a dentist, and so on. But all of that can be explained by the fact that, of course, she is here for a considerable period of time. But standing back from it, it all seems to have been a temporary visit to the UK. And she was at school here because, for very understandable reasons, the parents didn't want her to miss out on her primary school education. But what have I missed something? What is there that means that the balance should in fact reasonably be struck in favour of England rather than Colombia?
Well, my lord, the word temporary is a word that, in my respectful submission, we have to be quite careful with, because it's used generally in the authorities here as distinct from permanent. And I think in ordinary English usage that's a perfectly understandable difference. But there are temporary stays and temporary stays, if I can put it that way. So a child who comes for, as in the Re-A Zambia case, a 2-week holiday and is then kept there against the consent of the other parent, where that's an ongoing situation where there's a known lack of agreement and so on, is a different temporary stay from a child who is coming for an agreed 3.5-month trip, which is extended by agreement.
Yeah, I'm using it in a slightly different sense. I'm using it that everyone's agreed that she should return to Colombia. And so what's happening in the meantime is temporary within the context of that agreement. It means in the meantime.
Well, to an extent I accept that, my lord, but it looked at through the eyes of a 6-year-old, which is what we're having to do here. She is, in effect, just living her life, and these are the factors the judge goes through at 54 to 56. My lord has summarised some of them just a moment ago. Being in school, being registered with the GP, living in the paternal family home, her grandparents, her cousin, all there. The dog is there. She's not only registered with the GP to cover, as it were, unexpected emergencies, but we see, and I'll have to ask my learned junior to find me the page if we need to go to it, but there's an appointment made to a paediatric service of some kind. The actual appointment is in June, but the referral for that appointment must have taken place substantially before that, knowing what one knows about the speed with which those kinds of appointments come around. And so the fact that there was an adult intention shared to go back is one of the factors, for sure, and I don't shy away from that, but nor does the judge shy away from that, because she deals with that in her judgment. But that doesn't prevent the child, through her own perspective, becoming sufficiently integrated in the social and family environment here that her presence here can be properly described as habitual residence, which is what we're ultimately asking. There needs to be what's referred to in some of the other authorities as a degree of stability, and I think it's in the French version of the Lord will correct me if I'm wrong, I'm sure, but I think it's in the French version of the old European Convention, European regulation that previously one looked at and that's referred to by Mr. Justice Hayden, that the French word, where we use permanence in English, the French word is stabilité. And I think it's a judgment of Lord Justice Thorpe, where he accepts High Court decision of Mr. Justice Singer that this implies we need to think, when we think about permanence as opposed to temporariness, we're thinking about stability of the child's life rather than necessarily an intention that it be forevermore.
Quite, and that's, I think, the point my Lord's making. Temporary is doesn't reflect stability, because you're here for a temporary period, for a temporary purpose.
Well, with respect, my Lord, I don't accept that. That you can't have stability while also being temporary, because this is what I say about this temporary and temporary. If one had an agreement that a child would come for 2 years, that could also be described as a temporary trip, but it wouldn't in any way stop habitual residence.
I understand that, but the temporary nature of what had happened here is clearly a significant element. And as my Lord's identified, everything is pointing towards a temporary stay, retaining links, retaining connections, expectation of return to Colombia, and then suddenly we have paragraph 59, where the judge says no sufficient degree, and it appears principally because of the child being at school.
Well, that's obviously one of the points that my learned friend makes in one of his grounds of appeal, is that there's an over focus on the school, but I think one has to be quite cautious because the judge is very specific in saying by no means all of the integration that she's looking at comes from that. But I mean, I would say with respect that it's quite normal to think with a child who is old enough to go to school that the fact that they do go to school is a very significant factor in thinking about their habitual residence, because it is the place that the child has a life away from the parents, in a way that particularly with a child of this age, they otherwise don't really. And so this is what allows this child, along with the ballet classes and other extracurricular activities, all of which she's going to be making friends with other children her own age, knowing adults who aren't members of her family through school, getting to know other families and therefore being invited to birthday parties and play dates and so on. And so the school in itself opens up a whole plethora of other issues which are relevant to the question of whether this child is sufficiently established here that it's reasonable to call it habitual residence.
I think, if I may say so, I don't want to take you out of order at all, but at some point I think you will have to assist us on a distinct ground of appeal that's made against you, which is that, for example, at paragraph 56, the judge refers to a number of facts concerning school and these wider factors that you've just reminded us of very fairly. These are events that post-date the relevant date. So why isn't that an error of law?
Well, there are two things about it. I mean, the first is that it's, in fact, the mother's counsel who relies on the change of school as being relevant. One goes back up to 49 of the judgment. It's Mr. Evans who says to the judge that the fact that there was a change of school in the September is an indicator that she can't have been that stable in her original school. And the judge, I don't know that the judge specifically deals with it. She records that that's the submission that's made. But I respectfully think my Lord is right, that the fact that it happened in September can't be relevant to the question of how integrated she was, but it wasn't us who were reliant on that fact, it's mother. And she's trying to say that the fact of a change of school shows a lack of integration. She also tries to say that the lack of good progress, as it were, at school indicates a lack of integration. I think Mr. Newey was alluding to the point that I'm about to make, and if so, I adopt it, and if not, I make it of my own volition, which is that children who are entirely and undoubtedly habitually resident in this country also underperform at school. And it doesn't mean that she doesn't integrate at school. The fact that she was still underperforming at school in January, I think is the relevant date of this year, indicates that it's not to do with the short-term issues, but to do with her as a person. And if we need to, we can look at the school report, which is at page 171. I don't know that we do need to look at it, but with all its reference, 171 is her school report, which talks about her having great progress and making lots of effort at school. So there's sort of a number of sides to the coin, if a coin can have a number of sides, in relation to that. And so we've dealt in the written skeleton in some detail with the school argument, which I think is ground 4. And in effect, I'm not sure that I have very much to say about ground 4 that isn't in our skeleton argument. But that is, to some extent, out of turn. Well, also, I need to deal with the data retention issue, because although my learned friend concedes it probably doesn't make much difference, nonetheless, it is a significant part of the mother's case. And a great deal is said that seems to impugn the father being in any way straightforward about the passport issue. So just to take us through some evidence, at 143 of the bundle, this is the evidence that the application for the passport was made on the 2nd of January. And my learned friend says there's no evidence that the application was made on the 2nd of January. Well, here it is, page 143 of the bundle. A great deal is then made by my learned friend about the father not disclosing the email that's now in the bundle from His Majesty's Passport Office. Well, it's a little difficult to see what it's supposedly gained by the father apparently not disclosing it. I mean, this has never been put to him. He has never had the opportunity to file evidence about this issue in relation to the fact, apparently, of him not disclosing it. So all I can tell you is my instructions, which is that, as I would say respectfully is often the case with these sorts of emails, he didn't notice it until several days later, by which time the passport had already arrived. And as we know from the contemporaneous messages that the learned friend took you to, which I think are at 149, yes, 149 of the bundle, the father immediately did tell the mother when the passport arrived, or the British passport arrived. I mean, it was printed on the 13th, is what the email from HMPO says, and the email says specifically, it will now be passed to our delivery people. And so it's not at all surprising that it didn't arrive until the 16th. The 13th is a Saturday, so we can reasonably think probably nothing much happened on the 14th. 15th it was picked up by the delivery people, and on the 16th it was delivered. The father immediately told the mother.
Sorry, where are we looking?
It's page 149 of the bundle, my lord.
Yes.
It's about 3/4 of the way down, 16th of the 4th, 24. At 1814, father says the documents have not yet arrived, by which he means the support.
Yes, okay, only the passport.
Only the passport
Yeah,
arrived.
that is.
And
The documents are taking a little longer.
the documents are
I think one of the points that was made, if I understood him correctly, by Mr. Jarman, was that what father did not say at that point was that they're expected in a couple of weeks' time.
And I think, my lord, as I say, there's no written evidence about this, because at no point at trial was this indicated to be an issue the father needed to provide his evidence about. So all I can do is to tell you that his evidence, if he were to put it down, would be that he didn't see that email until some time later. But what he did do was phone the passport office to find out where the documents were. And we can see he refers to that just over the page, about 8 lines down, 4:29:24, it says, I called to find out about the remaining documents, including her Colombian passport, last week. So, having received the British document on the 16th, I think if we follow the calendar through, that's a Tuesday that he received it. During the course of the following week, not day not specified, but at some point that week, he calls, and we can see, so he specifically says there he called, and back up at the bottom of 149, he says, I'm told it can take 1 to 2 months.
Yes.
And his evidence is that that is what they told him on the phone. That he wasn't referring there to the email that we've now provided, because on the 25th of April, it was there in his inbox, but he hadn't seen it, actually viewed it.
I see.
That's his evidence.
So your instructions are that even by the 25th of April he hadn't seen it.
I believe those are my instructions. He found it on being asked. I mean, I think it had been opened at some point between then and now, but it was only on being specifically asked by this court what evidence there was that he sort of trawled back and found this document. I don't think he'd never read it, but in a sense, once your passport arrives through the door, it's not terribly important to you to get an email saying your passport's been printed and is now in the post. So I don't think the significance of that document, of that email, was ever apparent to him. But certainly my instructions are that there was no sense in which it wasn't relayed to the mother. And if that is the suggestion, then one has to ask why he did immediately on the 16th tell her the passport had arrived.
It's quite. I don't think one can take this any further, but the texts are a little curious in the sense that it starts, the documents have not yet arrived, only the passport arrived. You might think, well, the news is the passport's arrived, but the other documents haven't.
I think, my lord, I can take instructions about this if it matters, but I think what we have here is two parents who communicate in a variety of ways, including by speaking to each other, and that these messages are, in a sense, a sort of continuation of a conversation that's also going on in other mechanisms. And so I was saying to my junior this morning, there's an extent to which these messages don't flow very neatly. And I think that's the explanation for that, is that they aren't the whole story. The father's criticised by Moylan for not providing actual evidence, objective external evidence of when these documents arrived at his house. I don't for the life of me know what that evidence would look like. When the post comes, it comes. And so I'm not sure what it is that he could possibly have provided that he hasn't provided. Nor, given that the documents arrived precisely within the time frame of that email, according to when he told the mother they arrived, I'm not sure what else we learn from any further evidence in any case. And they came per the schedule of the email. So although he says he was told on the phone it might take up to 2 months, they came 2 weeks later.
Well, I think what Mr. Jarman says, and I'm not saying I agree with it, but I just want to be clear. I think this is the case you have to meet. I think what Mr. Jarman says is that in around the middle of April, when mother left on the 14th, the father was aware that the passports, the UK passports, were shortly going to arrive, and that the other supporting documents, including the Colombian passports, would arrive by late April. Yeah. And that if the mother had been informed of those facts, she would have stayed in the UK and delayed her departure to Colombia by perhaps a couple of weeks, because that would have enabled her to take their child back with her which had always been the agreed plan. Now, none of that may be correct, but I think that's what's being said.
And I think if I can take that point and just jump for a moment to the conclusion of all of this, that is one of the reasons that we say this court is not in a position simply to determine this issue. If you find, contrary to my case, that Mrs. Justice Morgan has inadequately assessed this matter, that is part of the reason, with respect to my lord, why we say the matter has to be remitted. The father has never provided the evidence that I am forced to simply say. The mother has never provided the evidence that Mr. Jarman puts forward that she would have remained. And those are matters that may well call to be tested in evidence. That may not be a matter that can simply be taken from the papers. Because certainly my understanding is that the mother returned when she returned because she had pressing business engagements to get back to. And so we don't accept that it is as straightforward as she would have just stayed. She went back when she went back because she had her own reasons to go back. So that is all to jump to the conclusion that if the court is against me on my main case, the matter can't simply just be decided now, because these matters that are now said to be so significant, and the judge is criticised for not having dealt with them even though nobody raised them, the fact that nobody raised them means that the evidence isn't there.
This is on the date of the wrongful retention repudiation.
It's the date of the issue, but also the question of, insofar as the mother's consent is relevant to determining when things, when that date is.
No, I understand that you're saying that in respect of the challenge to the relevant date, your submission is that we're not in a position to replace it if we think it's wrong with an alternative date. That would have to be reheard.
Yeah.
So, yeah, thank you.
Sorry, just take a moment. So I think that's all that I need to say on the passport issue. Insofar as this court is in a position to be thinking about relevant date, and I don't know whether this is in fact now conceded based on what my learned friend says in his submissions, but our case is that given when the passports came back, and given what we say is the position about Colombian law, again a point which was never put in evidence before the judge because nobody ever raised this issue as being relevant, that in fact the earliest practical date when a return could have been effected by either parent is the 1st of May. Now we say there's no basis for saying that the 1st of May is actually the date, because by then there are other discussions going on between the parents about not disrupting the school term and so on. And it's only, and the reason that everyone alights, or well, the mother and the judge alight on the 30th of May is that's the first time the father says in the message. I think it's a verbal discussion, in fact, it's not written down anywhere. It's the first time he says that he's thinking about whether it would be better for the child to stay here, and that is in his statement, I think, or it's in the mother's statement, in fact, 362 for your note. That
Page 362.
Page 362, my lord, yes. That it's the end of June, the father first states his actual clear intention to return. End of May is when he first posits the idea about it.
End of May.
End of May. That's where 30.
Sorry, where are you reading from?
My lord, at 362.
In the bundle?
In the main bundle.
362 is an exhibit?
It's an exhibit to the mother's statement. So this is the idea. This is the point that the end of June is when the father firmly says he's not going to return the child. But end of May is the first discussion about the possibility, and
Where do we see that?
that's it's not dated, my lord, but at 120 of the bundle, which is statement, paragraph 56. The father is recounting here a verbal conversation between the parents and my learned junior and Mr. Evans before the case began in front of Mrs. Justice Morgan outside court, agreed that both their clients' instructions were that this was the 30th of May, and that is where that date specifically comes from that leads into Mrs. Justice Morgan's judgment. And so
Just to be clear, 30th of May.
Yeah.
Because I'm afraid wrongly I'd noted down you had said 30th of April at some point.
if I did, I misspoke.
All right.
It's entirely possible that I did, but yes, 30th of May, and that's where the judge's decision to alight on that date comes from, as distinct from the father's case at trial, which was that it was later than that. My lord, I'm conscious of the time, but I suspect I don't actually have very much more to say. If I could just take a moment and look at my note. So yes, the particular importance of my point that until the passports are actually back, the child cannot re-enter Colombia. That takes us then to the difference between the 1st of May, when there's the theoretical possibility of return now that the passports are back, the 30th of May, which is the date the judge alighted on, some possible date later than that, which was the father's case at trial. And simply put, our submission is it doesn't make any difference which of those dates it is. The judge herself says very clearly that as between the 30th of May and any date later than that, her analysis is the same. She says that explicitly in her judgment. And if one thinks about the factors that my Lord Justice Singh took us through at, it's no longer on my front of my bundle, but I think around 54, 55, 56 of the judgment, none of the factors that the judge identifies changes in any way between the beginning of May and the end of May. They're all either enough or not enough, whatever the date is. So there's a sort of quite significant argument about the date and the judge being wrong about the date, even though she was invited by the mother's counsel to accept the 30th of May. But it's, in a sense, a distinction without a difference. I haven't dealt with the mother's own return to Colombia and the impact that has on habitual residence, which is a separate ground of appeal. Our primary case on this is that the judge was well aware of that, but that this is an assessment or a criticism about weight. So it's obviously well within the judge's mind that this happened. And what weight she ascribes to that is, unless it is really outside the bounds of what the evidence can support, a matter that is, for her, the argument on our case is simply that by the time the mother left, on the 14th of April, the child had been here for then 3.5 months. And again, repeating my point, all of those factors that we set out, that are set out in the judgment that we rely on, were also all in place. Now, of course, part of our case is that the mother's presence here did indeed help in establishing the child's habitual residence, because when we think about the Supreme Court Re B decision, Lord Justice Moylan took us to this point earlier. This is a case where all of the child's immediate family were here. Of course, the maternal family in Colombia remained in Colombia, but the paternal family here were here. But it wasn't the case for the majority of the period of time between arrival here and relevant date, that one parent was in the other country and the other was here. They were both here. Now, of course, I have to accept the point that Lord Justice Singh makes, that the intention of being here was a temporary one. But I do think there is some relevance to the point that I make about it wasn't absolutely as clear cut as that. And I'll just take, if I may, to the CV and job application point, which is at 147, I beg your pardon, of the funding. Bottom of 147, in the midst of a number of entries on the 26th of February.
I'm sorry, which page is this?
147, my lord.
Thank you.
The mother says, "Can I start bothering you with my CV? I don't know how to edit it." The father says.
Sorry, where I can't find that
I'm
yet.
about 10 lines up from the bottom of 147, my lord.
Oh yes, okay.
And then the long entry, which is the biggest single entry there, is the mother. And she's quoting a bit from her CV, I think, is what I understand this to be, or a cover letter perhaps. "In the last 10 years, I've had the opportunity to train and encourage many people. I feel that being part of the base in UK would be a divine opportunity to continue growing." So this isn't a fixed intention. I'm not suggesting more. I'm not trying to put more weight on it than it carries. Only to say that there was a more fluid situation here than it is presented as we came for 3 months and we always knew it was exactly only 3 months and then everybody was going back. There was some fluidity to it.
Even accepting that for the moment, right? On the mother, there's no dispute of fact. The mother left the UK on the 14th of April.
Yes.
And the relevant date the judge found was the 30th of May. So is this right? She wasn't back in the UK on the 30th.
Didn't come back in that period.
Yeah. So the judge has in effect found that the child's habitual residence was the UK on the 30th of May, in circumstances where she is separated from her mother at that point.
At that point, yes.
Yes.
And that is obviously one of the relevant factors, but it's not a determinative factor, and it is a factor that the judge decided what weight to give, and in her overall analysis decided it didn't weigh sufficiently to mean that the habitual residence that by then had been established on the basis of all of these other factors that we've looked at was undermined.
Does the judge, and this is not a rhetorical question, can you just show me in the judgment, does the judge refer to the absence of her mother at the time of the relevant date? And what weight, if any, she gives that factor?
Can I just take a moment to find
Of course,
the
yeah.
answer to that? Thank you. My learned friend points us to paragraph 17 and 18
Yes,
of the judgment.
thank you.
So that's in the introduction to sort of setting out the mother's case. So it's clear that that's been put forward and that it's been noted by the judge. So it can't be said that she's overlooked it because she's recorded it.
Right.
I'm just seeing if there's anything more specific in the think Lord Justice Peter Jackson once referred to as the engine room of
Yes,
judgment.
Quite. And again, one's always conscious that one is not marking an examination paper, and and you have to read it as a whole. And I understand all of those points, and I've often made them myself in judgments. But yeah, if one goes to the engine room of the judgment, you do expect to see the critical factors being analysed. And I may be wrong, but it may be thought that the fact that the child is separated from her mother is at least a significant factor in saying whether somewhere is her habitual residence. I don't know.
Well, of course, it's also fair to bear in mind in this case that when she arrived, by agreement of the parents, that she arrived without her mother. That was their plan. The mother followed on.
Oh yes, I understand that.
I may be about to be given the answer to our question. I can see my learned junior is writing a note.
That's very helpful. Thank you.
I'm not going to be given the answer. I think the answer is a different question.
No, all right.
I see. It's just a face. I'm happy to take reply if you get to. Okay. You want to stop now?
I mean, what we can see. I beg your pardon. I'm aware of the time. What we can see, my lord, is at 55.
Yeah,
there's a discussion.
paragraph 55.
Paragraph 55, page 74.
Thank you very much.
There's a discussion about the relevance of the mother being here, and it's specifically noted at the third line of that paragraph until April 2024, and the judge deals with this by way of how the mother's presence up until that point is helpful from the child's perspective in establishing a life here. I have to accept she doesn't specifically say what happened when she left, but the fact that she says on the face of it, remaining until April 2024, I think suggests that she was well aware of it. And it, as you say, my lord, we're not marking an exam paper. So the implication is that it's dealt with.
Thank you very much.
Can I say for helpfulness, apart from what happens at the conclusion of the case, I don't have any.
You need. I'm not sure. Maybe you think. Maybe you have. You've dealt with the effectively that the judge took into account post-May factors when considering the child's habitual residence at the end of May. I think you might need to deal with that a little bit more.
Detail.
So we'll stop now and start again at 2:00.
All rise at 8.